Hi guys! So we are gathered here today. It was supposed to be the start of jury selection for Christian Eppinger, but it is now a plea hearing because Christian Eppinger is entering a plea. There are no closed captions on the feed at this time. We're going to turn the volume up the best we can. Otherwise, replay, there should be captions available on this stream. Before we get started, I have a quick clip about Fanny's thoughts on the success of this YSL trial. This was before Christian Eppinger was entering this plea. This was a few days ago.
My message to taxpayers is it was an amazing time. We had 19 convictions. The community is safer. We made sure that we got the resolutions we want. If they're unhappy with sentencing, they should elect other judges.
So the solution here to this hot mess is apparently to elect other judges. Now, I don't know if this is going to be a negotiated plea or not. We know Jeffrey Williams entered a non-negotiated plea, which is kind of like putting it in the judge's hands. A lot of the other pleas were negotiated, which means the district attorney's office and the attorneys were working together to come up with terms and agreeing to them. So I don't really know how that's the judge's problem. And then again, the acquittals that we had for Diamante Kendrick and Shannon Stillwell. I mean, you gonna blame the judge for a jury acquitting? So here we go. We're gonna find out what happened with Christian Eppinger. Remember, this is AKA Briss. He was facing several charges. He is already doing time for another matter. So I don't know how this is going to resolve, but let's say his sentence was nada here. He'd still be in custody as far as I know. But he was the one who is charged with the attempted shooting of a police officer. And we saw some of the video in the YSL trial, one largely through the hearings, because Hilton wanted to get the footage in of the apprehension to contradict the defense's claims that APD, the Atlanta Police Department, doesn't treat suspects very well, doesn't treat Cleveland Avenue residents very well. And Hilton said, I want to be able to show the jury how nice and peacefully this apprehension went. That was that hot mess. So let's see what happens. We've got Whitaker ready to go. Big thank you to Factual Lie here. I was in meetings all morning. Factual Lie is like, tag. Christian Eppinger, no longer jury selection. We've got a plea going. So here we go, chat. Oh, yeah.
Good morning. Can everybody make sure the audio is muted on your laptops? Okay, we are here for jury selection unless there's going to be a plea. So what's the decision, Mr. Johnson?
Oh, so non-negotiated Alford plea? Bonnie!
Swear him. If you can stand up.
A squeaky chair.
And come to the podium. Can one of y'all come up and swear him, please?
Brian, you thought about that when you're on the court, you know, never got. What's the record statement for the first right? Christian Eppinger.
All right. Who's going to be handling this for the state? All right.
Mr. Eppinger, are you at this time taking under the influence of any alcohol, drugs, or medicine? How old are you? And how far are you going through? Are you able to read, write, and understand the English language? Do you understand that you are charged with the following charges in this indictment? Count 1, conspiracy to violate the RICO Act, which carries a sentence of 5 to 20 years. Count 27, armed robbery, which carries a sentence.
Here, let's see. I have a little volume booster. There are no captions yet, but YouTube usually generates them for the stream itself, within it replaying. But let's see, can we like boost it? I have this little volume booster. So just so you guys know, if you have your volume like all the way up, I'm going to kick it up 2 more levels from a 3 to a 5. And I'm going to switch over to my, I'm writing a tweet to complain. That way I can test the sound and not blare your ears out. And then we'll go back to playing it. All right, it's a little louder. So let's go back here. Does this help, chat?
Count 27, armed robbery, which carries a sentence of 10 to 20 years or life. Count 28 of this indictment, hijacking a motor vehicle in the first degree, which carries a sentence of 10 to 20 years and a $10,000 to $100,000 fine. Count 29, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years. Count 31, theft by taking, which carries a minimum and maximum sentence of 1 to 5 years. Count 32, attempted murder, which carries a sentence of 1 to 30 years.
Yes.
Count 33, attempted murder, which carries a sentence of 1 to 30 years.
Yes.
Count 34, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years.
Yes.
Count 35, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years.
I thought it counted.
This is what you're charged with?
Yeah, this is what you're charged with. Count 36, possession of firearm during the commission of felony, which carries a sentence of 5 years to serve consecutive to any other count of indictment. And possession of firearm during the commission, count 37, possession of firearm during the commission of felony, which also carries a sentence of 5 years to serve consecutive. Count 38, participation in criminal street gang activity, which carries a sentence of 5 to 20 years. And count 38, another count of participating in criminal street gang activity, which carries a sentence of 5 to 20 years.
Yes.
And count 47, conspiracy to commit a crime, which carries a sentence of 1 to 10 years. Do you understand that you have the right?
Hang on, isn't there a 48 also?
And count 48, criminal street gang activity, which carries a sentence of 5 to 20 years. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your lawyer, Mr. Johnson, about all the facts and circumstances known to you regarding the charge in this indictment? Have you spoken to him regarding any potential defenses? Do you need any more time to discuss this case with your attorney? Are you satisfied with his counsel and representation? Do you waive formal reading of the indictment? And do you waive any defense, if any, with respect to the indictment? To your knowledge, have you been arrested?
Hang on, Mr. Johnson, that's normally addressed to the attorney. Do you waive that?
Yes, Your
All
Honor.
right.
Do you waive, have you been arrested on these charges, Mr. Eppinger? And Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Johnson, do you know of any outstanding warrants related to these charges? And Mr. Eppinger, I just advise you of the minimum and maximum for these sentences. Are you aware of them? Do you understand that in pleading guilty to armed robbery, you're pleading guilty to a serious violent felony? Do you understand that you will serve the entire prison portion of the sentence imposed for a serious violent felony without the possibility of parole? Do you understand that while you would be eligible to be considered for participation in the Department of Corrections Administered Transitional Center or work release program on the final year of your incarceration, you will not be eligible for any other sentence reducing program other Department of Corrections or Board of Pardons and Parole? Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections? Do you understand that this plea is a blind plea, also called a non-negotiated plea?
This is not negotiated.
They will recommend the plea. Your Honor, can we do what our recommendation is?
That's fine.
Okay. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that which is recommended by the state?
Yes.
Do you understand that if you enter a non-negotiated plea You do not have a right to withdraw your plea once the sentence has been announced. Do you understand that this is a guilty plea which is permanently recorded on your criminal history? Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court?
If you aren't watching the screen, I think it's important to know that, and maybe it's just Christian Eppinger's listening face, but he looks so skeptical listening to every word that Hilton's saying, as he should be, as he should be.
Do you understand you are currently on probation or parole? Your probation or parole may be revoked based on your entering a guilty plea today.
Yes.
Do you understand that you are placed on probation of any kind? You cannot violate any criminal laws in any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes.
Do you understand that you are not allowed to possess or use a firearm on probation? Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial, and that this is true regardless of the advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison? Do you understand you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are given the following rights? And Mr. Eppinger, I'm going to ask you to say yes, ask each right that I see.
Well, say yes if you understand that that's a right that you're giving up and you want to give that up. Say no if that's not the right answer. Say I don't understand if you don't understand. Okay?
The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses and witnesses.
Yes.
Your right to assist with counsel hired by you or to court-appointed counsel who cannot afford an attorney in a trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence. The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have a charge against you proved beyond a reasonable doubt. The right to appeal if convicted of these charges after the trial. Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No.
It is my understanding that you're asking the court to consider this plea under North Carolina versus Alford.
And is that every count that he's going to be pleading to?
Yes, Your Honor.
All right. Well, I'll have to hear why.
Is your decision to waive these rights and enter a guilty plea because you are a felon? Guilty, or are you pleading under, or asking the court to plead under North Carolina v. Alford?
Alfred.
Are you pleading guilty because you have decided it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and place you in the same position as if you were convicted by a jury at a trial?
Yes.
Now, Mr. Eppinger, based on the negotiations, do you understand that you are pleading to the following counts?
That the state's going to move, you're, as a part of this plea, going to be null crossing certain counts?
Yes, sir.
All right, what is the state moving forward on?
Your Honor, the state is moving forward on count 1, conspiracy to violate the RICO Act. Count 27, armed robbery. We are going to null cross count 28, hijacking the motor vehicle in the first degree. We're moving forward with count 29, possession of a firearm by first offender probationer. We're moving forward with count 31, theft by taking. Count 32, attempted murder. Count 33, attempted murder.
I'm getting confused because she flip-flopped. I don't know why this is blinking. I'll go to a picture if my camera keeps blinking. It's like we're moving forward with count 1, and then she started talking about what she's going to null pros. Is she still listing off what she's going to null pros?
Count 34, possession of firearm by first offender probationer. We have null process count 35, possession of firearm by first offender probationer.
Count 35 was dismissed or not null process.
Oh,
Is you just trying to during the first charge. Count 36,
wait, back up. What do you mean by the first
during
charge?
the first series of the case round of that case. Count
And I want to point out that the attorney already had to correct this. The last time we had a hearing with, I think it was 3 defendants left. The judge, I think this is Eric Johnson, had to say, we looked at the indictment, they dropped that charge, why is it still on here? So Hilton won't let this go.
35 was,
Yes, Your Honor. We filed a motion to have that count dismissed.
All right.
We put it with count
all right,
number 34.
okay.
Count 36, possession of firearm during the commission of felony. We are null process count 37, possession of firearm during the commission of felony. We're null process count 38, participation in criminal street gang activity. He's pleading to count 39, participation in criminal street gang activity. Count 47, conspiracy to commit a crime. And count 48, participation in criminal street gang activity. Mr. Eppinger, with respect to those charges, if I need to read them again, how do you plead to those charges to which you're pleading to?
Yes.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for the felony, for all the felonies, to file a habeas corpus petition challenging the constitutionality of the guilty plea?
Yes.
Do you also understand you have 30 days from today's date to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion to withdraw this guilty plea, which does not mean it will be granted. That's just a time period that you can file. You understand that?
Yes.
And Your Honor, in this case, we're to go to trial.
Here's what they believe they'd be able to prove.
On Zoom.
Yes, Your Honor. The state would expect to show a number of different things as we move forward with this indictment, Your Honor. As you have heard, this is the YSL RICO indictment in which the YSL gang is an enterprise consisting of a group of individuals associated with that. Although not a legal entity, they were started in 2012 in the Cleveland Avenue area of Atlanta, Georgia, and they claim affiliation with the National Blood Gang. The founders were Jeffrey Williams, aka Young Thug, also known as Slime, Walter Murphy, also known as DK, and Trontavious Stephens, also known as Love. They identify with a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. They often wear clothes with the word Slime and YSL, and also have tattoos with the name YSL.
All right, so when someone takes an Alford plea, that would mean, I think that you have the evidence to prove something against me at trial. I'm not going to risk it. I'm maintaining my innocence. Here we go. But we heard a lot of null process, and I'm blocking something, so let me move my picture. Now, null pros means we're not prosecuting. We're not prosecuting the thing. So a lot of the things that we just heard they're not prosecuting, the possession of a firearm, all of these things say armed robbery. So, yet she's showing us a timeline of what she would have been able to prove at trial, which kind of makes sense for the things he's pleading guilty to under Alford, or pleading guilty to in general. But some of this overlaps with what they're choosing not to prosecute at all. So this seems like it's blurring the line here. If you're going to null pros something, you don't read your factual basis for the thing. But what do I know? What do I know? Maybe I'm wrong. Maybe that's a special thing they do in Fulton County. But this just seems like she did the math, tick ticked off a bunch of things, already had a timeline, and doesn't know how to adjust what she's talking about. Just like she couldn't remember that the one specific count that's been dropped for months and she's already had to be told that was dismissed by you guys. The 35, one of the possession of a firearm by a first-time offender probationer, was dismissed months ago. So long, deep sigh there. On the positive side, shout out to Classy Beats. Are you streaming right now? Aren't you streaming right now? So make sure you guys say thank you to Classy Beats. This is super, super awesome. Hopping over here to drop 5 gifted subs, making the chat green for one last YSL Slime Fest. So big thank you to Classy Beats. Guys, we are here to talk about the Christian Eppinger plea hearing. Now is going to be jury selection. I'm assuming Classy's also talking about that, but we'll go back to Karen Reed coverage because that's what I saw in his thumbnail. So when we're done here, we can go over there and it will be a great time. So if you don't want to watch Karen Reed, come hang out for Club Classy tonight. And let's see. Yeah, multitasking. Can't believe this is over. Hi, Ken. And if you have a problem, take it up with the judges. Take it up with the judges. 1,000,000% here. Project Banshire, it says Classy is a class act. 1,000,000%.
Specifically for Mr. Eppinger, Your Honor, he has several cases in this indictment. Your Honor, under count 1, the RICO conspiracy, Mr. Eppinger had an armed robbery in May of 2016 with the victim, Sylvia Hill. He was convicted of that crime, spent 4 years in prison, and was released in May of 2021. In October of 2021, Your Honor, he did the armed robbery of Mr. Darius Smith.
All right, so did that May 11th armed robbery, did he, was that a first offender conviction?
It was a first offender conviction. It was reduced from armed robbery to robbery. And I'm going to go into more detail, Your Honor. I'm just going to give an overall timeline. In January of 2022, there was a theft spot taking. About 3 weeks later, on February 7th of 2022, was the attempted murder of Officer Rogers and Sergeant William Johnson. And then in February of 2022 was a conspiracy to stab and kill Mr. Rayshawn Bennett. Your Honor, we went over the crimes that were charged in this indictment. So again, on May 11, 2016, which is Act 61 of count 1, the RICO conspiracy. This happened at 245 Mall Drive Southwest, which is in Atlanta, Georgia, in Fulton County. The victim, Ms. Saravia Hill, was coming home that day with her daughter. Mr. Eppinger arrived in the subdivision with 3 other males in a vehicle. He got out of the car, held Ms. Saravia Hill at gunpoint in front of her daughter, robbed her, took her vehicle, and went and fled the area, Your Honor. He was picked up about an hour later off of Cleveland Avenue, where he actually got into a car crash off of Cleveland Avenue. This is some of his in the middle picture, the picture of him on social media in and around the time of this armed robbery, Your Honor. That is, the picture on our left is the area where Miss Saravia Hill was robbed, and then that is the car that he stole from her, and then ultimately got into a car crash. And at this time, Your Honor, Mr. Eppinger was going by the moniker on his Facebook page, YSL Trial.
All right, so what it looks like they're doing here, let me fix this display. You notice that Hilton said this would have been Act 61. So it looks like she's reading the factual basis for this as an underlying act for count 1, rather than reading the act as charged, because he was also charged in this indictment with armed robbery for this incident. So she's reading it into the record as an underlying act, even though they've chosen to null pros it. Unless I heard that null pros wrong. We have to go back and listen to that because that was confusing. So
it's Christian, but he changed the B to C with the same monikers that the blood had used. That he did. As I mentioned, Your Honor, he was convicted of this crime in December 2016 with a negotiated plea. The victim, Ms. Hill, came in, understanding he was 16 years old at the time, asked for leniency for him, in which his armed robbery was reduced to robbery, and he received a sentence of 10 years instead of 4 years balanced on probation. Mr. Eppinger got out of custody in May of 2021. Within 5 months of that time, he was back on the block of Cleveland
Got a picture.
Avenue with his YSL associate. In this picture specifically is Durante Beebe, and Mr. Eppinger is in the middle, wearing Keep America Slime Against flat clothing and all of those same monikers that came with YSL in the game. And this is on September 29th, 2021.
And was there a probationary condition that he not be connected with known gang members?
Yes, Your Honor. Within 3 weeks of that picture, Your Honor, we had the armed robbery of Darius Smith on October 12th, 2021 at 47 Cleveland Avenue, which is also known as the Cleveland Avenue Park. This is where a number of YSL gang members hung out. And
this is going to be counts 27, 28, and, well, 27 and 29
Yes.
of our indictment. Okay.
And while Mr. Darius Smith was at the park that morning, hanging out with a friend because he was waiting for his brother, the defendant, along with Durante Beebe, approached Mr. Darius Smith, holding a gun to his head and to his side. They stole his watch, his chain, his earrings, his wallet, and ultimately they also stole his right beard. This happened about 4:15 or 4:45 p.m. That afternoon. While there are kids, this is a library, Your Honor, so in the front of the park is a library, and in the back is a playground area.
Oh my God, sound.
This is some of the surveillance video, Your Honor. So what you're going to see in the surveillance video in a few moments, we believe that the robbery happens to the left of the screen, so where the cars are coming from. And so you can't see the robbery off camera, but what you're going to see, and I want you to notice, the adult woman, they keep looking in that direction. We believe this is when the robbery is taking place. You see them rush and get into the car, and then you're going to see another young man come down the steps, and she kind of flags him and tells him to hurry. So we believe this is the point in time the robbery is.
Hold on. This kid that's running out at the end is slow. The whole family is in the car with the door closed. And then another member of their party comes running out like, you better hurry up.
And the vehicle that's stolen is in the background of this video. For this case, Your Honor, the state had phone records. We were able to get the phone records for Durante Beebe. He was using his phone at the time, or in and around the time of the armed robbery. Mr. Eppinger was not. What we have is, at the bottom of the screen, Mr. Beebe's phone pings in the location of the robbery, and then we see his phone pinging later on in the afternoon to where the car was recovered, which was not in the same location.
Yeah, Demise and Willow took a plea also last week.
The car was actually recovered at the village at Castleberry Hill, which is about 10 minutes or so from this location. This is the victim, Mr. Darius Smith. You see him wearing his chain prior to the armed robbery, which was one of the most significant pieces that they stole because his chain was very distinctive. At the time, he was a rapper. He went by the name of Trap Commander, and the chain says Trap Commander on it. After the robbery, we had Sergeant Pierre, who was the lead detective on this case, was able to get Instagram records of both Durante Beebe and Christian Eppinger. And what we found after the robbery, Durante Beebe is holding the chain, so that's him on the end. And then we found that Mr. Christian Eppinger, we believe, actually bragged about the robbery, and that's the video that's going to play next.
không phải một trăm mình bên không bây giờ nói tối ra hết quẹo đi ở đây đi đi phá ta đi thôi mà sao đi đây đây là quên đó đó là để cái mà ở đây chẳng nghe hiểu nó đó là gì đó là tao cái này quên đâu how much actually get from the phone? Né? Tá no phone? Ela tá baixando. Então, olha. O que vai haver?
I can't hear anything. I can't make out any of this. So, sorry guys, can't help.
You need 3,000 first. Yeah, I'm gonna put back. I ain't gonna wait. Hey, you wanna win? I got flat. Go. What's good, guys? I'll take that. I'll take that. You see that bit? Blessing outside. Put it down, man. Man? That was crazy. Now watch again. Whoa. Everyone there? Everyone out there. You can tell that everyone might him. I'm so hard to say what, huh? See right here, this is money. You can buy that. I think they got 3,000 per ticket. Oh, no, I ain't gonna catch it again, take your time again, let's buy it back again. Look at the same way you did when I took the gun off. You can have it. You can have it. I ain't got huh? I made it sit down on the curb. They thought you were going to get the put out and sit down on the curb. I seen the earrings in the ear. Oh, take the earrings out too. You told me you going to do it like that? Yeah. Me, everything but.
This is awful. This is awful.
In that clip, he's talking about taking the chain and he's trying to sell it back to the victim. He also talks about the watch, the earrings, and all the items that were taken from Mr. Smith. And then he talks about the fact that he put the gun to him and put him on the ground. When we met with Mr. Smith, just to understand what happened to the case, I asked him, what happened to you? He said, the defendant put me on the ground, he sit on the ground before taking the items. And so we believe that this is him bragging about that armed robbery, and this was posted about 4 days after the armed robbery. The next, Your Honor, we have overt act number 149. Again, Mr. Eppinger is with 3 other YSL associates, Durante, BB, as well as Mr. Mooney Lee, also known as Slime White Shorty. So again, posting pictures in the same clothing, OTS, only the slime clothing. Then he's posting on social media, Cleveland gave me the game, YSL gave me my name. We were studying back then, we wasn't studying the thing. Free ESPN, which we believe every slime place nasty. The real ones, not the
ESPN.
So again, him posting about the game, and then him with guns and things of that nature. This is all on his social media. Then we have January
Shout out to Amy
2022, Your Honor, which is count 31 of the indictment of theft by taking. This is at the Zaxby's on Northside Drive. The victim in this case, Mr. Willie Moore, was a Uber Grubhub driver. He was picking up an order for a customer. he walked inside of the Zaxby's, and this is the surveillance video from that incident, Your Honor. That's Mr. Eppinger in the black hoodie. That's Mr. Moore walking up to the Zaxby's.
This is why you gotta lock your doors.
See, Mr. Eppinger turns back around, leaves his friends, gets into the vehicle, and then drives off with the vehicle. Mr.
Just
Moore
like
did not
that.
give him permission to drive that vehicle. After this incident, a BOLO was put out. Members of APD gang unit, Sergeant Johnson, they were able to immediately identify him as Christian Eppinger. The car was later recovered 3 days later by Officer Cogdale at 340 Thomasville Boulevard, which is in southeast Atlanta, with now bullet holes in the car that weren't in there previously. And then
Turn the car with bullet holes.
On February 7th,
Or left it somewhere.
2022, in which officers were doing an operation to arrest Mr. Eppinger on the armed robbery warrant from October 12, 2021. They had planned an operation in order to get Mr. Eppinger arrested. It started off with some surveillance at a house off of Clear Drive. They saw Mr. Eppinger leaving that house. There was one officer, Storno, or investigator Storno from the gang unit, who gave information to some of the other officers that were helping with this detail. Those officers included Officer Rogers, Officer Teasley, and a number of other individuals who were preparing to participate in assisting with this incident.
And this is the officer involved shooting.
Officer Sergeant Johnson was able to, he was doing something else, but he was able to get to the Cleveland Avenue area within moments of this occurring. As I said earlier, Officer Storno was following Mr. Eppinger, giving updates on his whereabouts. They eventually ended up at 221 Cleveland Avenue, which is the Chevron gas station, which sits at the corner of I-75-85 and Cleveland Avenue. Mr. Eppinger walks into that store. Sergeant Johnson's able to have eyes on him to update what his movements are.
Sergeant Johnson?
We have Sergeant Johnson, Officer Rogers. So Sergeant Johnson first gets on the scene. He's able to update the other officers about Mr. Eppinger's movements. Mr. Eppinger leaves that location and begins walking towards these apartment complexes, which is Colonial Drive. At that time, Officer Rogers, who's in his marked police car, is following behind. He sees Mr. Eppinger walking in. Officer Rogers then, in his patrol car, begins to follow behind, entering into the apartment complex, Your Honor. At that point in time, this is where the video picks up, Your Honor.
Right, and this is Officer Rogers' studio, right?
Yes.
6170, 6160.
Your Honor, what you see happens is Officer Rogers in his marked uniform, Your Honor. He is in the marked uniform. He sees Mr. Eppinger. He tells him to get down, get out. He's in his marked patrol car. and his marked gear, similar to something when he has on today. He is in the courtroom today, Your Honor. When he gets out, Mr. Eppinger does not follow or comply with any instructions, Your Honor. He asks to put the gun down, get out the car. Mr. Officer Rogers actually, in what you can't see, is actually trying to go from his firearm to his taser in order to reduce force. When Mr. Eppinger
What you can't see, which means we're relying on Rogers' word.
takes out a gun from right underneath his arm, this is where he's holding it, turns around and begins shooting. At that time, Sergeant Johnson had came in right behind him, and so I'm going to show you this angle, Your Honor, so that you can see what actually transpires in another angle. And you see Sergeant Johnson that's him on the left-hand side ducks. Mr. Eppinger returns fire back towards him as Sergeant Johnson is trying to protect Officer Rogers because he has now shot Officer Rogers 6 times.
Put the picture up.
Officer Rogers has 6 gunshot wounds, 4 to the right shoulder, to the posterior thigh, and 1 right and posterior scalp. I mean, it almost grazed his head, Your Honor. Only by the grace of God that Officer Rogers is still here with us today. At that moment, officers did not wait for ambulance. They actually put Officer Rogers in Investigator Stoner's vehicle, who arrived shortly thereafter, and then transported him to Brady Hospital. Now, this is Mr. Eppinger and phone call after.
What the hell you think? I don't give a fuck about Luke work. I really want thinking, bro. That shit happened so fast, bro. That shit happened so fast, man. I'm so hot now. I'm ran out on me with me. I can feel that shit. I was feeling that shit like, yeah, I'm like, that ain't shit pretty good. Nah, bro. That wasn't bad. Everybody keeps on my arm tripping. Hell nah, they can run out on you. Get a dick on you, but there you gonna be. You know, both? So what you gonna tell them folks? I ain't gonna tell them folks shit. What the hell you mean? And then you part. And then you gonna tell them folks. You know, what happened to them? Hell no, boy. You funny ass. I'm like, what you gonna tell them? So, bro, listen, bro. I'm gonna hear you gonna say, because you ain't got no explanation, boy. Well, what they mean, man, listen. Hey, man, don't be in the run up on me, pointing their gun at me, man. I might get out. I'm getting out, boy. I ain't getting out. Somebody told me they call it 12 in the way up there. Yeah, somebody, I don't know who it was, though. Who was all up there? They said it was an informant. I don't know. Somebody wasn't gonna vote, though, son. Little fault. Somebody wants to vote. Oh, damn. Breathe. Yo. The police, they hear you down there, bro. You said what? And the police, they hear you. Man, you might not know my name, bro. Hey, I'm calling you ain't going for that shit, bro. I ain't just talking, bro. I just want to ask you, just to tell you really, make all this type of shit you think that I just want to make sure that shit ain't, you know. Man, this all snakes and this vein cuts me. What the fuck, man? Y'all know me, bro. Come on, bro. Y'all know me, bro. I'm not going out there in or out there, bro. That's it. I said that shit too. I said, you ain't just free not to go off for that. What? They give me talking shit like, oh, you ain't never going home. So, we're gonna pop the shot. What? What they said you never going home? Yeah, you know they tell you to like it, bro. Yeah, I know. Man, you know what it is, man. Free BBT, free. I ain't even trying. I ain't trying to be in my for my life. I damn sure what time we did. But if you would have called me and saved it, would have been different, bro. I probably would have ran. But then,
Yeah. Man, I got things to get me on this gun. Popped out over with a gun, not so I later.
Got that with the gun?
Yeah.
People pop.
Yeah. Yeah, I ain't gonna keep talking about that shit on his phone, though. I'll just call it out. Yeah, I'll just speak. Hey, free. Yeah, I miss y'all young niggas, but y'all my favorite young niggas, boy. Man, look to your ass stupid hell, man. First you don't got that all off the phone and shit, bro. I'm not going to flash off his phone. I know. He's talking about whoever popped my phone in round one, y'all count our days. I seen that shit before I got locked up. I know. This is why I need y'all to do me a favor, though. What's up? I need y'all to drop one of the phones right quick, bro. My shit is going up, bro. Yeah, let me go look at your face. Nah, we go look at my views on YouTube. You got a phone down there? No, I ain't no phones in my street. I'm on my tablet.
So, Your Honor, while on the phone,
What's the worst nightmare for him?
you heard him laughing about the fact that he shot Officer Rogers, and then it's Callis' mouth at the end. He's worried about his YouTube views going up and wants everyone to go on YouTube so that he can now be more famous for what he just did as part of this YSL game.
So I think this part is a reach, because if you're on the phone, you have time to kill. Like, what else are you going to be talking about? It's not uncommon, you do something, right? You're infamously all over the internet. It's kind of a normal response for someone to be like, well, at least you're going viral. You can be famous now. That's just kind of the natural way a conversation about a video going viral of you doing something now goes. So I get that Hilton wants to make her case here, but it's not like the only explanation for that is he did it to go viral. He did it for the gram. Like,
Which is injuring an officer while he was trying to do his duty. But it doesn't stop there because he gets praised for it.
Yeah, man, free my nigga Big Rich, man. Yeah, man, I was saying that. Fuck that boy, spank that baby. Yeah, man, free my nigga Big Rich, man. Fuck the DA. Yeah, we catch the fire on this shit. Yeah, we about to catch that fun for nigga. We come to catch. You know what it is. Yes, sir. It's a little free game. Yeah, YSL shit. That's the little, yeah. Slack game. Slack, man. Pretty game. That game for fun, though, sir. That game for fun. Okay. Bro, it's on the young boy. Yeah, man. Somebody nigga Big Rich, man. By the way, the game way. Big Rich was a big hit, man. They gave my nigga a bun today, man. Smell me. What is that? They gave my nigga a bun today, y'all. Shit crazy.
And that was Rodelius Ryan while he was in prison posting YSL the gang way because he was receiving bond for this horrible activity. And then we have on February 22nd, 2022, while Mr. Eppinger is in custody at the Fulton County Jail, which is now count 47, count 48 of the indictment, Your Honor, conspiracy to commit murder. On February 2022, Jada Myrick had stabbed Rayshawn wife and Lucy Bennett while in custody, Your Honor. And that is Mr. Bennett on the right-hand side, and this is a screenshot of the video of that stabbing that occurred on February 9, 2022. Given that Mr. Myrick did not complete the task at hand, which was, we believe, to kill Mr. Bennett, Mr. Eppinger.
Sorry, I got that poke Lucha ass up. Oh, no, hell no, I didn't do it. I didn't do it. I ain't good.
What area you at?
They already got bro? No, I'm the right street, man. Oh, yeah, right street. Yeah. Oh, but you don't know who that. Yeah, I don't know who that is, bro. They say you had a goddamn pop with that. Nah, I had my little pocket pop. Right.
And their little partner was Jaden Meyer. But since he could not finish it, Mr. Eppinger wanted to take on the task.
Yeah, that shit upstairs though. Oh, yeah, they got me on PC with the boy Luch. Oh, they was on PC. Yeah, hey, find out what I can get for that, bro. Huh? Man, find out what I can get for that, bro. What's what? You know what I'm talking about? I know what you get for. I just told you why I'm at. Okay, so what you need me to do? Find out what I can get, man. I just told y'all the woman to go on with. We're gonna go with. Lucha, nigga. Oh, you in the drama? Yeah. No, I'm gonna make a call right now. I'm gonna let you know. I'm gonna let you know when you gonna make a call back. Man, I call back anytime, bro. I've been trying to call you, bro. I like, bro. I know if one nigga gonna make it to the straight, bro, Obama gonna do it, bro. Obama gonna make it good. Man, yeah, you know that, but we got down. I'm ready to just put some. I'm ready to put something in some here and see. You know what I mean? What they gonna send to you? You got down. What's I need a lawyer, bro. I need a lawyer and right. Yeah. You do, and that's a big deal right now. If you get that boy, so. Yeah, I don't see nobody not playing with you, bro. You come there, bro. That's what I'm saying, bro. I was trying to get dollar numbers so I can have a slime, man. I know I was gonna holler at him about that shit on the phone, but he gonna catch nigga drip just like you get caught. I'm gonna pull up to the Yoda tonight. Bro. Boom, therefore, I'm gonna pull up to the Yoda tonight. That bitch ass supposed to be sending something, bro. I'm gonna pour a shot to the side some one-on-one shit and just have the job. Hey, yeah, bro. They tell him my situation too, bro. I already know he done heard about it. You know I'm gonna tell him, bro. You know I'm gonna tell him I got you, bro. Yeah, who all right now?
And Your Honor, so he was talking to Antonio Sumlin on that call, and some key things that I want to point out in the call is Mr. Eppinger says, I was trying to talk to Dolly so I could talk to Slime. From the previous trial, you know that Dolly is Mr. Jeffrey Williams' sister, and Slime is the name that they call Jeffrey Williams. So it's the state's belief that he was trying to reach Dolly so he can reach Slime.
They all call each other Slime, though. You even said, like, what was it, like 15 minutes ago, every slime playing nasty. You brought up the make everyone slime again. Like, now when we hear just slime, it must mean Jeffrey Williams.
Find out whether or not, if he does this, can he get a lawyer? That's the only thing he was asking for payment was a lawyer. And here, Mr. Sumlin again has his YSL tattoo on his chest, and Mr. Eppinger has the YSL tattoo on the side of his face. Again, showing that all of these crimes are in furtherance of this gang, YSL, in furtherance of this enterprise to continue to wreak havoc on the Cleveland Avenue community and the community at large, Your Honor. So we believe that would be the evidence that the state would present if we were to go to trial on this case today, Your Honor.
All right, so they're wrapping that up, and right before we hear Whitaker, I think this is a good time with this update from Thugger Daily this weekend. You can read the caption. It says, Lil Baby, that's Wham, Jeffrey Williams, Young Thug, Lil Baby are close. There's been a lot of drama because it's Lil Baby and Young Thug more than it's Lil Baby and Gunna. Lil Baby brought out YFN Lucci, Rayshawn Bennett, this weekend at the State Farm Arena in Atlanta. So, I I don't think that's really reading that many tea leaves to say, oh, funny.
My message to taxpayers is it was an amazing time. We had 19 convictions. The community is safer. We made sure that we got the resolutions we want. If they're unhappy with sentencing, they should elect other judges.
And here is someone that is apparently subject to this Jeffrey Williams ordered, commanded jail stabbing. On stage with someone who's very close with Jeffrey Williams. I don't know, chat. I don't know. Seems like a big fanny flop.
Earlier I did speak. He did not have, for the 16 SC case, Your Honor, he did not have a special condition stay away from gang.
Okay.
However, what he did have was
Hey, Nick. Big Nick with the big head.
which he's to avoid persons or places of disreputable or harmful character, Your Honor. And then, as it relates to that case, there was other conditions that he violated. He never reported to probation upon release. It does not appear that he ever enrolled in the next level boys academy. So those things that he was supposed to do, he did not do as a part of his Your Honor.
All right, thanks for that clarification.
And Your Honor, we give a recommendation now, or our recommendation.
Yeah, I'd like to hear your recommendation. I'd also like to hear what his criminal history is right now, other than what we've already discussed, because I believe he's maybe got some other convictions.
No, Your Honor. So his only criminal conviction now is the robbery. He was revoked. His first offender was revoked, Your Honor, and he was resentenced on April 22nd, 2022, and he received 45 years to serve on the resentence, Your Honor.
Now remember that the way that all played out, this April 2022 probation revocation and resentencing, that was right after they granted him bond in this attempted murder of a police officer case. So there was talk at the time, and I think it kind of makes sense. They screw up, somehow give, you get all this, nobody gets a bond, nobody gets a bond, nobody gets a bond. You can get a plea deal. You can get out if you take a plea deal. And we're not going to give you any special conditions to stay away from the people you're supposed to be a danger to. But you can't get a bond. But somehow Christian Eppinger gets a bond. So it seems like around that time, Atlanta, the people of Atlanta, and obviously the police department, was pretty pissed off. How did out of all these indictments in this one case alone, how did this individual with all of these charges get a bond, but you're still denying it for others? So I don't know if they just like leveraged the probation as being, we can get him back in custody for another reason to fix our mistake, or what. And I forget what his bond amount was. I'll look that up.
And he had juvenile history, Your Honor.
What's his juvenile history?
We do not have the juvenile charges.
Okay, what's the state's recommendation?
Your Honor, the state's recommendation is to ask count 1, conspiracy to violate the RICO Act, 20 years to serve. As to count 27, armed robbery, 20 years to serve, concurrent to count 1. Count 29, possession of a firearm by first offender probationer, 10 years to serve, concurrent with counts 1 and 27. Theft by taking, 5 years to serve, concurrent with count 1, 27, and 29. Attempted murder, count 32, 20 years to serve consecutive to count 1, 27, 39, 31. Count 33, attempted murder, 20 years to serve consecutive to count 32. Possession of a firearm by first offender probationer, 10 years to serve concurrent with count 33. Possession of a firearm during the commission of a felony, 5 years to serve consecutive to count 33. Count 39, participation in criminal street gang activity, 20 years to serve concurrent with count 33. Count 47, conspiracy to commit a crime, 10 years to serve concurrent with count 39. And count 48, participation in criminal street gang activity, 20 years to serve concurrent with count 39. So that means 65 years to serve. We're asking that to be served consecutive to his probation violation, which is 16 SC 143618.
143618.
That's right. And Sergeant Johnson would like to address the court at the appropriate time.
All right, so we're going to get a victim impact.
I'm sorry.
Do you want to, right before we get this victim impact, do you want to look at the board again? Let's see. All right, so what did we have null pros? The hijacking of a motor vehicle. This count 35 was already previously dismissed, but it's listed here also. You know, they're not prosecuting it. And then 37 and 38, possession of a firearm during commission of a felony, and then one of the participation in criminal street gang activity. So that's what we had null prost in all of that reading. The way Hilton read it at the beginning was very confusing to me. It seemed like a whole chunk of those beginning counts were being null prost that aren't actually being null prost. So glad we had that visual there. Yeah, this is not going to be a light sentence. Shout out to Cash Money Cass in the building. Judge Whitaker.
My name is Will Johnson, WILLJOHNSON. I'm a sergeant with the Atlanta Police Department, Homicide Unit. At the time of this event, I was a detective with the APD gang unit. I was operating undercover capacity, just kind of laid out the event. I mean, you've seen the video. And just my background, I've been in the department for 18 years. Prior to being in APD, I was in the Army. I was in 75th Ranger Regiment. I have 4 combat deployments. I've been in firefights, gunfights, grenade fights, rocket attacks, IEDs, car bombs. I've had a lot of experience with trauma. I think this was the most traumatic event that I've ever experienced in my life. And I think and it's not because of a gunshot, you know, somebody getting shot, or I see this all the time. It was just the intent and the act. It was an execution. It wasn't an attempt to get away. It wasn't a fight or flight type, or it wasn't a flight in the fight, right? He was trying to fight. He wanted to kill this officer, and he made every attempt to do it. He didn't take a shot and run. He stood there and fired round after round after round into Officer Rogers, and it was probably one of the most helpless events that I've ever experienced. And he didn't even run until he started getting shot at, and then he fled like a coward. And so I think about this day all the time. It comes back and forth in my brain all the time. I know with Officer Rogers, he does the same, and it's probably not going to change. I think back to like when I approached him. I remember like the look on his face, and I've seen that look so many times, and it always ends in death. And so when I looked at David, I thought, yeah, there's no way he's gonna live. There's no way. He had that glassy look, that stare that was just gone. The light was out. And we tried everything we could on scene. He was shot so many times, so there's so much blood. I remember there's just so much blood. I could taste the blood, the iron in the blood, like I tasted it for like 2 days. And so I remember my clothes, I was just like, That was the other thing. I remember I was just covered in blood, like from chest down. I'm sitting here covered in blood, and I'm sitting here for like hours afterwards, covered in this blood, smelling this blood, and waiting to make statements and everything, and not even knowing how he was doing. I'm thinking he's dead, and this guy just got away with it. And so I guess I'm just here to ask you. I mean, so like our ability to do this job, and when I go to work every day and put on this uniform, and do this job, and when I go to work every day and put on this uniform.
Hold on, did the volume just get quiet? I think the boost kicked off. Maybe that was them. Okay, you know what? Let me not change it because it might have been it might have been the court audio, so I don't want to blare our ears out. So we'll just keep going.
Kiss my kids goodbye. Like, we don't know if we're coming home, and we accept that to an extent, right? That's kind of part of our job to just be prepared for that. But our ability to do that is backstopped in the belief that you, Judge, and the courts are going to show up for us the way we show up for you. And so that's basically what I'm here asking, is for you to show up for us and to provide whatever, I didn't even catch what the max was, but whatever the maximum sentence that you could provide would be appropriate in this offense.
All right, I appreciate you sharing that.
Thank you.
Officer Rogers was present for when he did not want to proceed.
Yeah, and I actually recall Officer Rogers' testimony from the prior trial. All right, Mr. Johnson.
Yes, Your Honor. Before you stand, Mr. Christian Eppinger has stated before the 25-year-old lifetime without a resident, Your Honor. And as an attorney, I want to thank you for the opportunity to provide this plea today, the opportunity to represent Mr. Eppinger. As an attorney who was here from the beginning of the first trial, I have a unique perspective of this entire case, Your Honor. And I just want to extend my appreciation to all the members of the state and their tireless work on this particular matter. Your Honor, however, we must say, this entire case, as evidenced by the state's recommendation and evidenced by the officer who just testified, this entire case has been a witch hunt against Mr. Eppinger solely because he was involved in a situation with an officer. The reason I say that is the state just presented to you a timeline of events. If we go back to the first event in 2016, Your Honor, Mr. Robbie Hill testified at the original trial. In that case, and nowhere in the discovery is there any mention that the other individuals that were with Mr. Eppinger, that they were affiliated with YSL, that Mr. Eppinger was wearing any red clothing or anything else, that Mr. Eppinger had the YSL tattoo on his face. The car was recovered shortly thereafter, so there is no showing that this automobile was stolen to benefit, profit, or to help YSL in any way.
All right, now that's the 16 SC case.
Yes, Your Honor.
That's already been taken care of.
What I'm saying is, Your Honor, that is alleged in this case as Act number 61 for the RICO count. So what I'm saying is, they are alleging that that is part of the RICO, and there is no allegation whatsoever, any facts that my client was affiliated with YSL at that particular time. So moving forward to the other incidents on this case, Your Honor, there's a situation involved the October 12th armed robbery in this case. And we'd like to point out that my client is charged with these particular offenses. And it also is evident that, as I said, the state is attempting to get Mr. Eppinger because there was a co-defendant on these charges as well, Your Honor, Mr. Durante Beebe. And the state recommended a sentence of 10 certified for Mr. Durante Beebe for these charges. And I think that is very important because Mr. Durante Beebe was the individual who was immediately identified by the victim in this case. He was identified some by his facial pictures, but also by physical disfigurement on his hand. And it's important to point out that the victim in this case, Mr. Darius Hill, who would have testified in this case, additional evidence would have come out that his initial report to the police officers, he gave a description of an individual that did not fit Mr. Epinger's description. In his first conversation with the officers, when he went to the police office, he identified another individual as being the person who perpetuated the crime. He stated that he was given that information because this was word on the street. So there was no viable information to identify Mr. Eppinger as a participant in this crime. Later, the officer who would have testified as Matthew John Pierre, who was the lead investigator on this case, Your Honor, he would have testified that they received an anonymous tip telling them that Mr. Eppinger had been involved in this situation from a person who alleged to have viewed the robbery. Your Honor, the witness in this case testified that the individuals who perpetrated this robbery were wearing masks, and he could not identify them. So it's very hard to say that an anonymous tip who says that they saw this in masks would have been able to identify Mr. Eppinger. That is why Mr. Eppinger's name was involved in this particular case. Subsequent to that, the witness went in to meet with the police officer to identify a photo lineup. Mr. Eppinger was identified in that photo lineup. However, Your Honor, the video, if this matter went to trial, the video of that interview would have shown irregularities by Mr. John St. Pierre in conducting this lineup, where when presenting the information to the victim, he took Mr. Eppinger's picture from the bottom of the stack, placed it on the top out of order, and then shoved it in his face for him to make a selection, at which time he picked Mr. Eppinger. He had no prior information regarding Mr. Eppinger. He did not know Mr. Eppinger or anything else like that. And that is very important, Your Honor, because the state in this matter is alleging that a video that you heard Mr. Eppinger that was made on October 16th is him bragging about this robbery. In that video, you hear him saying that, you hear Mr. Eppinger saying that he has contacted a person attempting to sell something or whatever. That is important because that video was made on October 16th. The identification of Mr. Eppinger was not made by Mr. Hill until October 20th, Your Honor. And at no point in his conversations with him had he mentioned that he had been contacted by the person who tried to who had robbed him, that there was an attempt to sell back anything. And then also, Mr. Eppinger on the video stated that the person he was attempting to sell the chain to was coming from Henry County, and Mr. Smith states that he lives in Forest Park. So he would not have been coming from Clayton County, Your Honor. So there are numerous inconsistencies. Nowhere in that video is Mr. Eppinger being involved with a co-defendant in conducting this robbery. As Mr. B, we know Mr. Eppinger is present. Nowhere does he mention conducting a robbery with another individual, and nowhere does he mention taking a van or anything. And also, Your Honor, in that armed robbery, that van was recovered shortly thereafter too, so there is no showing that the van was taken to be sold for YSL benefit, to be sold for YSL transportation, or to benefit anything other than possibly the individuals who took that car, taking it for a joyride at that particular time. Mr. Smith testified that his car was ransacked, but it was not damaged. So there were no items stolen off of his car or out of his vehicle.
And that's the count, one of the counts that's being non-crossed, right? The hijacking the motor vehicle.
Yes, Your Honor.
But it goes to the armed robbery, Your Honor. It's very
I
important.
understand, I'm just trying to make sure I got it all.
Because, Your Honor, why that's very important is because, as I stated before, Mr. Beebe, the co-defendant of these charges, he was allowed to plead to a reduced charge of robbery and given a 10 to 5 cents in this case. The fact that the state is unwilling to do the same with the co-defendant in this matter, Mr. Eppinger shows their intent toward Mr. Eppinger wanting him to serve the mandatory minimum of the armed robbery sentence, which, given in light of the probated sentence that he has right now, is a mere formality unless it's one consecutive, Your Honor, I'd like to point out. And Mr. Eppinger's probation was revoked, as the state stated before, correctly. He did not have any provision that he was supposed to stay away from any gang members because there were no gang charges in his first crime. And the allegation that he was supposed to stay away from individuals of ill repute or harmful character, Your Honor. The individuals that hang with are individuals in his neighborhood. He's a 17-year-old child. So I'm sure he does not know the criminal records of everyone, of all the children and teenagers in his community. No, I'm not supposed to be with this guy because he's a harmful character or anything else like that. But we'll point out, prior to this incident that involved the police officers, there have been no revocations of Mr. Epinger's probation and no other arrest warrant. He was arrested for this, and all of this came to life. Now, Your Honor, you saw the video, as stated before, we go back to finish up on the armed robbery situation. As I stated before, Your Honor, if the matter did proceed to trial, we do believe that there will be sufficient inconsistencies with Mr. Smith's testimony, numerous things that could possibly invalidate his identification of Mr. Eppinger in this particular case. At this point out, these additional facts, while we do believe that they are present, they may not be enough to carry today, which is why we believe that this plea is within the best interest of our because we do not believe that the state's presentation of these facts are 100% accurate and that their evidence is 100% solid. We do believe that Mr. Eppinger does have a defense in this matter, but the uncertainty if this matter was presented to trial is the reason in which we state that this matter is within Mr. Epinger's best interest.
And a part of Alford is essentially an acknowledgement that, well, you are not conceding guilt, you are acknowledging that there is sufficient evidence from which a jury could conceivably find guilt beyond a reasonable doubt, correct?
Yes, Your Honor.
And you've discussed that with Mr. Eppinger. And Mr. Eppinger, you agree that the facts are such that a jury might find you guilty of all of this? All right, go ahead.
So, yes, Your Honor. And we would then like to proceed to count, the most important counts in this case, count 32 and 33, involving the attempted murder in this situation. Your Honor, I've practiced law for over 20 years now. Majority of the times when an individual is shot or shot at, that's an aggravated assault. Most times. In this particular situation, the state has chosen to step into the mind of Mr. Eppinger and say that he had the intent to kill these officers. In this particular situation, charged him with attempted murder. One officer who was not even struck by any bullet or anything else like that. So we do believe that he has been overcharged simply because the district attorney's office, from the beginning of this case, has used inflammatory language and rhetoric in this particular matter. In the initial interview, in the initial press conference regarding this situation, they said that Mr. Eppinger attempted to assassinate this officer. As you heard the video yourself, Your Honor, you saw what happened. It happened in a matter of seconds. There was no pre-planning. Mr. Eppinger wasn't out there trying to get anybody. He didn't know anything about this warrant. He didn't know that they were looking for him. He had no idea if this was going on in this particular day. Because as he contends his innocence from not participating in the armed robbery, Your Honor, he would have had no idea that there was a warrant for his arrest. And you heard on the video, at no point in time did Officer Rogers identify himself. At no point in time did he say, I have a warrant for your arrest. If you heard the video on the first trial, you heard it again today. At no point in time did he say that. And Your Honor, would also like to point out that at no point in time, excuse me, do you have a speaker? And Your Honor, one thing about it, and I'm going to show the state marking as defense exhibit number 1 for the purposes of the hearing, Your Honor. You have heard numerous times that at the time of this shooting that Officer Rogers was uniformed. That is incorrect, Your Honor. That is a blatant fallacy. If I may provide to the court exhibit number 1, I'll show to the state. Your Honor, this is a photograph that was taken from, that is a capture, that is taken from the body camera of Officer Storno, who the state has admitted was present at the scene, and that is a picture of Officer Rogers laying in the grass after the officers had moved him to a safe position after he was shot. As you can see, he is wearing a hood, he is wearing a mask, and he does not have his badge on the front. He was not in his full uniform at the time of the shooting.
There you go, chat. So we've talked about this, but I don't think the defense attorneys in YSL Trial 1 really pulled out a photograph and said he's in a hood, wearing a mask, and is not uniformed. Now, you heard the name Storno mentioned. Storno testified during Trial 1. Storno seems to be the go-to person to write out these affidavits for probable cause. Hilton made a reference earlier when she was doing the factual basis that Storno notated, he identified himself. He was in a marked police vehicle. Basically laying the foundation that it was known, Christian Eppinger, his intent at the time of shooting, he was aware that he was shooting at an officer. It seems like Storno wrote out that affidavit because that's the only reason I can imagine Hilton would have mentioned Storno. Storno also wrote the recent affidavit for Miles Farley. Remember, they scooped Miles Farley up. He was riding in the passenger seat, and they wanted to take him into custody and arrest him because there was a firearm in the glove box of the vehicle that he was in. I don't know any current updates on that. I don't think that they've actually brought down charges related to that incident. But just because they didn't bring down charges related to that incident with Miles Farley doesn't mean I think they took the target off his back. I'm sure APD is waiting for any second they can to jump out the bushes at Miles Farley or any of these other familiar names from this YSL indictment. But that's huge to me. As an officer, forget the justice aspect of it. But I can't imagine as an officer not wanting to follow the proper protocol. I just can't imagine not having the foresight what somebody might think is happening to them if I run up behind them. And what was he yelling? Like, get on the ground? Like, you're not really saying, Atlanta police. Even if it was a selfish reason, as an officer, I feel like best practice would be to very clearly identify yourself, especially if you are not wearing your uniform. So, all in all, I get that he was shot. That's a scary thing. But it could have happened with somebody else. It could have happened with someone that wasn't Christian Eppinger. I don't think that this happening was tied to... What was it that Aaron said? Let's see. Aaron said something about the probation revocation. Prior to the incident with Officer Rogers, there were no probation revocations. And Aaron says that that's crazy. Right, so now Eppinger looks like a menace, right? But I really think this is interchangeable. This could have happened with this lack of standard operating procedures with anybody else plopped into Eppinger's shoes. And again, just speaking selfishly, if I was an officer, why would I put myself in that position where I look like I'm running up on somebody in a hoodie? So, yeah, and FFS, good to see you, FFS says, yelling, get on the ground, I thought I'm getting robbed. And what did we hear Hilton lay out about Eppinger and the witness in the theft by taking, the burglary? That the witness reported he didn't sit on the ground, Eppinger put him on the ground while he was getting robbed, right? So the order of events, the physical action of getting on the ground is something that they're alleging that Eppinger did to somebody else while robbing them. So, oh my goodness, my goodness. And yeah, let me clarify. Good to see you also. Yeah, most definitely should have ID'd himself. Should have ID'd himself for the sake of following procedure and doing things the right way. You know, you put the whole neighborhood at risk. Like, what if Eppinger's... That was a lot of shots that went off. Somebody that lived in the neighborhood or was walking through the neighborhood could have been shot as well. So somebody else's mistake in not following procedure could have also impacted other people. So... Yes, Peter Ortiz. And that's kind of why I have such a gripe with this, is the officer said he identified himself when he was testifying, and the state has echoed that argument in motions hearings for the last trial and again today. So,
In no shape, form, but that is what Mr. Eppinger saw that day. He did not see an officer in his uniform.
Can we see the picture a little bit? Like, if we pause it? So we're like, let's see. I think I went back a little too far. He's got it in his hand right now.
You have heard numerous times.
Oh my God, we're gonna have to put on binoculars. Okay, guys, we're gonna zoom in on this. Let me see. Does it let me zoom in like this? No, what if I close this and then zoom? Is that all it's gonna let me do? Okay, what if I screenshot it? Let me zoom in. Let's screenshot. And I mean, it's pretty apparent. He's got a mask like for COVID. He's not wearing like a shiesty mask. But still, I mean, what was something that people that wanted to rob somebody during COVID, what is something that they did? I have an excuse now to wear what looks like a mask for the sake of hygiene and reducing contamination. I'm going to use that to look normal when I walk up on somebody. All right, if I edit this in Paint, can I share this tab? All right, you know what? I'm making this too complicated, but you guys can see he is wearing a hoodie. You can see the fold back here, and it's like, it looks like it's up around the back of his ear. Like there's still something going behind his neck, going over his hat. So he's got a hat, he's got a hygiene COVID mask, and a hoodie. So this is to me an accurate representation here from the attorney. So I think we were about here.
I didn't get on that. At no point in time did you hear me say, you have a warrant for your arrest. You heard him one time say, you got paper. However, Your Honor, we will contend, and I'm sure the evidence will show from the gang experts that will testify in this case. On the street, paper does not mean warrant. Paper means money. So therefore, saying you got paper was not indicating or giving Mr. Eppinger any knowledge that he has a warrant for his arrest. And any indication is shown, Your Honor, at his prior arrest, his prior conviction, when he was arrested before, he was taken into custody without incident. The officers informed themselves, showed us that he was taken into custody without incident, so the state cannot allege that, oh, he's just this big bad person who attacked police officers. Subsequent to this, as the officer testified that, oh, we thought that, well, he was going to get away with this. That officer was in the hospital at the time. He had no knowledge that Mr. Eppinger didn't even leave the conference. He was taken into custody. Probably by the time that they had gotten to the hospital, Mr. Eppinger was taken into custody. So
After the house that he was hiding in was surrounded by officers, correct?
Yes, he was taken into custody without incident at the time. He intended to hide. We admit that. He intended to hide and scare a child at the time. And therefore was taken.
How old was he at the time?
22. Your Honor, so in this particular situation, as stated before, the officer did not follow his procedures in doing so. And Mr. Eppinger did not know he was an officer at the time that he was attacked. When he came out, he had a gun drawn on Mr. Eppinger. So it's safe to assume that Mr. Epinger's focus would have been on the gun that was presented to him to see the order. Get on the ground where the person not identifying himself. So we do not believe that this is a situation where he was intending to kill anyone. And Your Honor, taking into consideration that this matter, this entire case, is a 65-count indictment that has been levied down, Your Honor. And in this matter, there were 2 counts of murder and another count of attempted murder in this matter outside of Mr. Eppinger. All of those matters have been reduced by the state. All of those matters have been
He made sure to emphasize by the state.
reduced. So what the state is saying is that the lives of their citizens are not as important as that of police officers, because we'll reduce the murders of people who we know are murdered, but we're not going to reduce for the purposes of a plea for this particular matter for Mr. Eppinger.
All right, 15 of the counts are against your client, right?
Yes, Your Honor.
Okay. And at least 4 separate incidents against your client, right?
In this particular matter, yes, Your Honor. Four separate incidents, Your Honor. And I point out, in none of these situations has anyone died. In any of these situations. Now, as it relates to the theft by taking, Your Honor, that matter, as it relates to our spoken of Eppinger, is probably the matter in which he has the least amount of defense or facts in this matter. The video is pretty evident. You see Mr. Eppinger from the video, into the vehicle, so we'll move along with that. As it relates to the last matter, Your Honor, the issue involving the conspiracy, you heard Mr. Eppinger on the telephone make a phone call, and the state is interpreting. Never does he say anything about Mr. Bennett. Never does he say anything about killing Mr. Bennett or anything else like that. The state is making the assumption that these is what his words mean. However, the facts are, as stated before, he was speaking to Mr. Antonio Sumner. Mr. Sumner and all these matters must be charged before they receive 15 years of probation for these particular matters. We do not believe that there's any evidence to show that any call was made to Mr. Williams to get Mr. Eppinger attorney or anything else like that, or anything was done, or there was any substantial step based on that initial offer to do it. And if it is to be construed as an offer, our contention from the defense would be that it was not an offer, just a conversation. But the state is saying that he was offering his services to possibly attack Mr. Bennett, and they assume that it's the murder of Mr. Bennett, Your Honor. However, there's no showing that Mr. Eppinger has ever made an attempt on Mr. Bennett's life, that there was any kind of order given down from the top or passed through any other parties or anything else, that there was an agreement between Mr. Eppinger and anybody else to harm or attack Mr. Bennett. So as such, in this particular matter, taken into consideration the fact that Mr. Eppinger is currently serving the revocation of his probation sentence for these particular acts right here, Your Honor. His probation was revoked solely because of these acts.
Okay, his probation was revoked and he was resentenced.
Yes, Your Honor. He was originally resentenced to 66 years. That matter was appealed and reduced down to 45.
All right.
And so, Your Honor, for these particular facts, like I said, there are issues with regards to Mr. Smith's identification of Mr. Eppinger as it relates to the armed robbery and the hijacking charge, Your Honor. As it relates to the attempted murder, Your Honor, I do not believe that there is a requisite intent to kill in this particular matter as pointed out. The state is intending, the state focuses every time that Mr. Officer Rogers was shot 6 times. 4 of those shots were in the shoulder, Your Honor, in his right shoulder, one in his leg, and a grazing wound in the back of his head, which is not meaning that that came from a direct shot, given the fact that placing the where his wound was in the back of the head, that bullet could have been introduced through medical evidence that the bullet could have ricocheted off of his shoulder, which was shattered by being shot 4 times, and possibly grazed the back of his head, Your Honor. If you look at the video, at no point in time is Mr. Eppinger behind Officer Rogers to shoot him in the back of the head, so therefore, a direct shot, we know he did not shoot him directly in the back of the head whatsoever. Eventually, it was a grazing wound that went past the back of the head, which is not determined as exactly how that may have happened. Yes, one before you heard Mr. Eppinger state from a phone call of Mr. Eppinger at jail, he said, laugh, when they put on the screen, laughing about attempting to murder. Your Honor, that is basically a far-fetched to say what Mr. Epinger's intent was during this conversation on this telephone with this other individual. It's not that he intended to murder this individual. He had no knowledge as to whether or not this officer was dead. He shot him in the shoulder. He at no point in time, given the close proximity that they were, at no point in time if Mr. Eppinger wanted to kill this officer, he could have shot him in his chest or he could have shot him directly in his head. There was nothing preventing him from doing that. Nothing.
Maybe it's a bad shot.
Or Your Honor, or maybe he's a good shot. The fact that he
I was gonna say, when we were hearing that he had the consent, because I didn't really pay, like, I don't know if they got into this, because remember, this attorney and Eppinger, they weren't really part of the arguments in trial 1. For trial 1, the defense attorneys were trying to keep out these videos and things that were going on at all, because it's extremely prejudicial to the other 6 defendants to show, hey, you know, this other alleged YSL gang member severed from this trial was shooting at an officer. Right? That's never going to be a great thing to put in front of the jury as something somehow associated with your clients. But here and now, hearing that it was consistent, I'm actually thinking, like, that's, you know, we've got some precision there in the firing. That wouldn't be me. That would not be me in the moment. Whether I intended to shoot a particular area or not, it would probably be all over the place. So I disagree with Whitaker there that maybe he's a bad shot.
forward and shoulder. That shows a very tight movement in the line. We're not going to get into that. However, the individual was shot. But at no point in time did you shoot him in any vital organ.
Hey, chat. So I was sitting here and everything looked fine. I didn't have anything telling me that there wasn't a stream going. And then I just noticed nobody was chatting. So I looked at my YouTube chat on my phone and saw you guys saying that I was buffering. I don't know what happened because I've had internet. I haven't lost it. So I don't know if that was a StreamYard thing. Sorry about that. The bigger issue is I don't know where we left off. So, how long ago was this? Let's see. Did Kat break it again? 12:03, so like 6 minutes, 8 minutes? Oh my goodness. I went on a whole rant, you guys. I went on a whole rant. Did we get through the part where Eric Johnson's listing off the statistics? Let's go back a little bit. I think that's where we were. If you guys did not see my rant, we were at the statistics part. So let's try here. We'll do it a little faster to catch up. Sorry. Oh, that sounds really fast, actually. Let's not do that. Let's do it normal. And volume boosted.
As far as the shot in the leg, Your Honor, the most damaging part of the shot in the leg would be if the bullet would strike the femoral artery. Given the fact that the average...
Okay, this is really far back. I think we did that. You guys, we were still chatting about that, so I was still live.
There were 3 counts of attempted murder, 2 counts of
Oh,
murder,
StreamYard issues.
4 counts of armed robbery, 2 counts of hijacking, and 4 counts of aggravated assault related to this entire indictment, Your Honor. And all of the murder charges and all of the armed robbery charges have been reduced to either aggravated assault or robbery. I want to say is unwilling to do so on behalf of Mr. Eppinger. I'd like to point out, as they allege in this matter, that YSL is a criminal street gang, Your Honor. I'm sure that if this matter proceeded to trial, each one of the gang experts would testify that association or membership in the gang in and of itself is not illegal, Your Honor. So the fact that Mr. Eppinger may have been seen posing with individuals on Instagram and may have been wearing a certain type of clothing in and of itself is not criminal. There is no showing that any of the crimes alleged by Mr. Eppinger have been tied in back to YSL in any way other than his alleged membership in them, Your Honor. They have furthered the interest of the gang in any way, financially, status, or anything else. Ms. Hill, the victim of the first armed robbery run, is not shown to be an adversary or anything with YSL. Mr. Smith, the individual who was robbed in October 21, is not shown to be an adversary of YSL, and that this was done to further YSL in any way, Your Honor. And so therefore, they allege that YSL operates over the Cleveland Avenue area, which is in Zone 3, Your Honor. So before I became a lawyer, I used to be a scientist, Your Honor. So I took out my legal hat and wanted to look at the numbers and look at things analytically, Your Honor. In this particular situation, in Zone 3, which is allegedly the YSL stronghold, over the life of the RICO from the time that they allegedly began on January 24th, 2013 to the time of Mr. Williams' arrest on May 8, 2022, there were 239 murders in Zone 3. However, citywide in the city of Atlanta, there were 987, so therefore, the murders in Zone 3 only represent 24% of the total murders in the city of Atlanta. As it relates to armed robbery, Your Honor, they only had 19.8% in Zone 3. As far as auto crimes, as far as auto theft, only 19.6%. The total crime in Atlanta. Aggravated assault, Zone 3, where they allege the YSL stronghold only represents 25% of all the aggravated assaults in the city of Atlanta. So these 7 events of violence in this case, 2 of which are associated with Mr. Eppinger, occurred over the course of 7 years. From January 10, 2015, which was the murder of Mr. Donovan Thomas as alleged in count 2, to March 14th of 2022, which is the alleged murder of Mr. Chanel Dress in count 49, there were these 7 events that we were referring to in this situation. So we contend that it points out that Mr. Eppinger was our first offender probation, so we do not have an extensive felony criminal history before this.
Because he'd been a juvenile before that.
Well, you are also felony criminal history, not access to the juvenile.
Well, I mean, the court's supposed to be able to have access to it for sentencing purposes. It just hasn't been presented. But what I'm saying is, yeah, I understand that the 2016 armed robbery reduced to robbery, and now that he's been resentenced on was his first felony conviction. But you also, unless you commit a limited number of crimes as a juvenile, can't have a felony history until you pass a certain age.
Well, we'd also like to point out,
So I had paused here, and I'll do a quick summary of the rant I did when StreamYard was doing whatever StreamYard was doing. You heard Whitaker say, well, the court's supposed to have access to that, like the record, even the juvenile stuff for the purposes of sentencing here. But what happened with Antonio Sledge? We get a whole reading of different things that are supposed to be part of Antonio Sledge's record, Mungtung, that aren't actually part of Antonio Sledge's record. They belong to somebody else. So, is this going to be another scenario where we don't actually have everything available to look at? And Whitaker's already making the presumption that there's some dirt there, right? You know, it wouldn't show, but presumably there's stuff there is where she's going. So just a little Moontunk reference there, which Joseph Papp with AJC says he's been following along with that. Tiffany, Jim, they're supposed to be filing the appeal for Moontunk this week. So we'll keep an eye for that. We'll get together to go through it. That is still in motion if you're wondering what's happening there. So the celebrations for Fani should not start.
But at the time of their arrest in this situation, the person who was the co-defendant with Mr. Eppinger had many more arrests and more convictions at the time. Last few seconds to 10 July that night. And Mr. Sumlin had more arrests than Mr. Eppinger also. He was given 15 years probation. So moving to what we believe is a proper representation in this case, Your Honor. Given the fact that the state is enforcing Mr. Eppinger basically pleads everything in this particular matter. As to count one,
All right, hang on. The state's not forcing Mr. Eppinger to plead to anything. I've got a jury waiting next door, and we can strike a jury right now if you'd like to go to trial.
what I mean by that, Your Honor, Mr. Eppinger wants to take a plea. Mr. Eppinger believes that the plea is in his best interest, Your Honor. We believe that the court will be consistent with their rules and consistent with the fairness that they have shown throughout the course of the trial. So we believe that that is in the best interest to do so. What I mean by saying that the state is forcing it, Your Honor, there have been numerous plea negotiations in this state, negotiated pleas and non-negotiated pleas, Your Honor. In fact, there have been, 25 pleas that were taken in this case, as only 2 individuals went to trial to verdict. So there have been 25 pleas taken in this case or dismissals in this particular matter. I would like to point out that none of those pleas did any individual receive any sentencing to run consecutive to sentencing that they already had. I believe the most stringent one was the last plea that was taken from Mr. McMullen, who was given 40 that was concurrent with his current sentence that he has right now. So, taking that into consideration, what I mean by saying forcing is to plead that I'm not saying that forcing, but the state has been unwilling to negotiate with regards to the reduction or the dismissal of certain charges as they have with other cases.
My recollection is that the last offer by the state was to 2 consecutive life sentences, so it seems to me like they've definitely come down from that.
No, the 2 consecutive life sentences was the form of Mr. Eppinger, what the matter was. The first offer that we were given in this round of things started with your offer.
Okay.
Life, I said, then they came down to 60 consecutive, then it was 40.
All right, well, I hadn't been privy to all of that. The last one I heard was, okay, 1 and not 2 life consecutives, but it sounds like they've been coming down the whole time.
But now
All right.
it's 65 consecutive.
Okay. Yes.
As it relates to count 1 for RICO, we would ask that my client be sentenced to 15 years to serve concurrent to count number 32. As it relates to count 27, Your Honor, the armed robbery, we would ask that my client be sentenced to serve 10 years to serve concurrent with count 1. The hijacking charge, count 20 years, being no cross. As it relates to count 29, possession of firearm by first offender, we would ask that he be sentenced to 5 years to serve consecutive with count 27. The theft by taking charge, Your Honor, we would ask that my client be sentenced to 10-year maximum, be sentenced to 5 years to serve concurrent with count 1. Your Honor, as it relates to count 32, the attempted murder, Your Honor, we would ask that my client be sentenced to serve 20 years to serve 15. We do not believe that they would have intent to murder the officer, Your Honor, so we believe that this is more in line with the factual basis of that aggravated assault in this case. So we ask him to serve 20 to serve 15 on that particular matter. As it relates to count 33, the attempted murder, Your Honor, we would ask that he be sentenced to 10 years to serve 5 concurrent with count 32. That reflects the fact that the other officer in this matter did not receive any injuries, and there is no showing on the video that he was ever in danger of receiving it. They allege that Mr. Eppinger shot at this officer, however, Your Honor, it is not apparently determined from the video that he did so, and we did not receive any information that the car that he was in was behind was struck by any bullets or any projectile was found from the ground, so we do not believe that the 2 counts and counts 32 and 33 are factually the same. We do not, that's why we made a difference in the resolution of those charges. As far as possession of a firearm by first offender at count 34, Your Honor, we ask that on the same crime be sentenced to 5 years probation on the second count number 32. For count number 36, possession of firearm by convicted felony, we ask that the crime be sentenced to 5 years to serve concurrent for count number 27. For count 37, being low cost, being low cost. For count 39, Your Honor, we ask that my client be sentenced for violation of gang law, Your Honor. We ask that he be sentenced to serve 20 to serve 15. Concurrent to count number 32. For the conspiracy act, count 47, Your Honor, we ask that my client be sentenced to serve 15 years probation. Concurrent to count number 1. And for violation of the gang act, we ask that count 48, my client be sentenced to serve 15 years probation. Concurrent to count 1, which based on the estimation we believe is a total sentence of 25 to 15, Your Honor.
Sure.
And I think that this is, like I said, fair with regard to the resolution of this matter, Your Honor, consistent with, as I stated before, on counts 27 and 28, the code of evidence B received 15 to 5, and 5 was a consideration because this matter was reduced from armed robbery to robbery. As it relates to counts number 47 and 48, the code of evidence on those matters, Mr. Summer received 15 years probation on those counts, Your Honor. So as far as anything that will be varying from those charges as it relates to the charges of the shooting of the officer, as I said before, we asked that my client be served 20 to serve 15, that this matter run concurrent with his probated sentence right now, Your Honor, which we believe that is fair and consistent with what's happened with the other matters in this case, Your Honor. But at no point in time has there been any allegation that Mr. Eppinger was the organizer or leader of this situation. No other defendant in this matter received more than 20 years to serve, and includes individuals that were originally charged with murder in this case. All the murder charges will be reduced to aggravated assault with no cross. And all of the armed robbery charges in this case, Your Honor, will reduce to robbery. The individual who received the hardest sentence on those were Mr. Huey, who had 3 armed robberies that were reduced down to robbery. He received a sentence of 20 to serve 9. And I would like to point out that in none of these situations, there is no one who has lost their life in any of these situations that this man has been involved in, Your Honor. And so we do not believe that if Mr. Eppinger is not taking his life, we do not believe that there should be a second sentencing in this matter, which is effectively taking Mr. Eppinger to life away from him, as he currently has a 45-year sentence. A second sentence would basically effectively almost be a death sentence in this matter, Your Honor, which would put any further. The state's recommendation would give him 110 years to serve, Your Honor, which is effectively a death sentence for an individual who did not kill anyone. And so therefore, while we can sit and say that individuals may think and say that, oh, well, the officer definitely has his right to say that he felt that Officer Rogers was going to expire based on his injuries. The facts are, none of the injuries that he sustained were life-threatening. He was back in service. Sometime after he was able to come to court and testify, Your Honor, and I believe he's on the force now, so he's resuming his activities, Your Honor. So if Mr. Eppinger has not killed anyone in this matter, he's standing before you today accepting the responsibility of the situation. You understand that, as I said before, there is a factual basis that the facts as presented by the state may present it up for a jury to convict it, and we do believe that we have facts that could possibly go the other way as well, Your Honor. It is the uncertainty of that matter which Mr. Eppinger seeks to avoid. He's under the understanding that if he was found guilty at trial, his fate would be in your hands, Your Honor, and we stand in that position as we are today.
Thank you.
Just a few things, Your Honor. I want to correct the record. So I'm going to show
Correct the record.
You
may. Have you shown it to opposing counsel?
Oh, so they're going to go after the shoulder shooting?
Your Honor, showing State's Exhibit number 1, Your Honor, which is Officer Rogers' vest. The video that Mr. Johnson showed you was after they took the vest off of him to perform life-saving services on Mr. Rogers. So you can see on that picture, there's some blood markings on Mr. Rogers' front of his badge. And we also have some pictures that we can show they were checked out of the Zoom, but shown on the Zoom that has blood on the back of his vest, Your Honor. So when he got out of the car, his vest was on. He shot him in the vest, and so they took it off to help perform the measures, Your Honor. So that is an incorrect statement that Mr. Officer Rogers did not have or was not in uniform because he was in his vest that says
It had the seal and his name.
his name on it, Your Honor.
Okay, that's interesting.
Going to
It's, Defense Exhibit 1.
So we don't have a
Exhibit
picture of
1
that?
are admitted.
Going briefly to the armed robbery, Your Honor, regarding Mr. Eppinger and this comparison of Mr. Beebe and Mr. Eppinger. When we
Let's refresh this and get you guys some volume. Let's see if this, so if you have it all the way up, you might want to turn it down in case this boosts it a lot. But maybe it gotten kicked off. What were we, 28 minutes behind? Yeah, that's way louder. So let's go up gradually.
we took that into consideration because that is what the victim told us, and it seemed as though Mr. Beebe was afraid to do it, but he was following the demands and the controls of Mr. Eppinger, which you can hear when he's bragging about it, what he said he did and how he spoke to the victim, Your Honor. So we took that into consideration when looking at Mr. Beebe's resolution, and Mr. Beebe did not have a prior armed robbery, reduced the robbery, when we decided to make that recommendation. And then as it relates to the stabbing of Mr. Bennett, the reason why Mr. Bennett was stabbed is not because he didn't have the opportunity, but because one of the law enforcement in our office heard the jail calls. They called the jail to have Mr. Bennett moved so he wouldn't be stabbed again. So it's not for the fact that he didn't do it, it's the fact that we were able to move Mr. Bennett to safety so that he did not get harmed again. So this notion that he didn't do it is because he didn't have the opportunity. Your Honor, we were able to get Mr. Eppinger juvenile history, Your Honor. So he had 2 burglaries, one from June 4th, 2015, which was almost a year prior to the armed robbery. And then he had another burglary on February 11th, 2016, so a few months before the armed robbery. He was adjudicated, it looks like the date is May 11, 2016, so we're not sure if once he was taken into custody, they adjudicated it, but they were joined for the purposes of the juvenile adjudication, Your Honor. Your Honor, my closing remarks here is that Mr. Eppinger is not similarly situated to many of the other defendants in this indictment. Mr. Eppinger received an opportunity to change his life when he got an armed robbery that he did at 16 reduced to robbery. He served 4 years in custody, and within 4 months, not a year, within 4 months, he was back to the same criminal behavior that they tried to save him from a year prior, 4 years prior to that. He never learned his lesson, not once. And what does he do? He robs somebody. Then when police are just trying to do their job, he takes a gun and he's not carrying his waistband. He's not carrying where he has to pull. It's literally tucked under his arm with easy access and begins firing off rounds over and over and over again. Like you said, Judge, he's not a good shot. But bullets have no names. You know, Mr. Johnson just said, well, the bullet that went to Mr. Johnson didn't hit him. That's not, they don't have any names. And for that reason, Your Honor, the state, we believe, has been gracious in our offer. Mr. Eppinger, looking at what he's charged with, he's looking at life plus 150 years. That is what the maximum sentence is for the charge that he's pleading to. The state, understanding that he already has 43 years, which most of that will be door to door, consider that 60 years consecutive is about 103 years. And that is why we made that recommendation, Your Honor, given that we believe that is substantial time in this case. So, Your Honor, the state is going to ask that you follow the state's recommendation. Mr. Eppinger had an opportunity to change his life around, had an opportunity to go to the next level, Boys Academy, had an opportunity to do all these different things, but he chose not to do that. He chose to go back into the streets, to live this life again. And here's where we are, and this is what it brought him to. And he had no remorse about it. On the jail calls, he's bragging about it.
I feel like if Hilton skipped this entirely, Whitaker would have either sentenced what she's already going to sentence, or maybe sentenced more strictly. Like, this just seems like, you know, when someone takes something too far, too much. You were already here, and now you're making me less enthusiastic about my decision, so I'm going to go away from what you're suggesting here. I think that's kind of where I would be if it was Whitaker. And yeah, I do think if you guys missed it, I'd put it in the chat. I know it was hard to hear, but according to Eric Johnson, Eric Johnson was arguing fairness, you know, take into consideration the way the pleas for the others in this indictment played out. You know, we had actual murder charges. Somebody actually lost their life. Reduced by the state in negotiated pleas down to aggravated assault. But here the state didn't want to take an attempted murder charge and offer any reduction on that particular charge. Read between the lines, probably because it involved an officer, and that would just be like political suicide for the DA's office. But
that's what he's doing. He wants to be this person in the streets. So we're asking you to hold him accountable to be that person in the streets.
All right.
Yeah,
Yeah, go ahead.
got another rebuttal.
As far as the allegation regarding the differences in Mr. Beebe, Your Honor, they showed you the photograph of Mr. Beebe wearing the chain. Mr. Beebe, there's no photograph of Mr. Eppinger wearing the chain. And so therefore, the fact that they say that the witness told them that the one person was running it, we do believe that the evidence that he's giving in the interview, we don't have a recording of what he said when he was in their office. However, the recording that he gave to the police officer at the scene of the crime, the recording that he had with the officers later on, and the recording with the officers at the time that he made the identification says none of that, Your Honor. So therefore, that evidence in and of itself should not be taken as 100% credible. It's subject to cross-examination and discrediting as well, Your Honor. So therefore, the state has not shown a significant difference between this situation. As Mr. Beebe is the individual that photographs wearing the chain after the incident, which would show that he's much more involved in being the scared person standing on the sideline. He's the one with the spoilers of the crime, Your Honor. And the state has evidence of that they knew at the time they gave his plea. Also, Your Honor, as they mentioned about the fact that Mr. Bennett was moved, the state still has not said any evidence that there was any agreement for Mr. Eppinger to do this. There's no showing that Mr. Eppinger had received an order or any kind of compensation to do this. So the fact that they moved him is irrelevant, Your Honor, because there's no showing that the crime of the conspiracy was actually completed in this particular situation, Your Honor. So the fact that they may have moved Mr. Bennett and Mr. Eppinger did not complete the crime is irrelevant, Your Honor. The issue and fact of the matter is not whether he actually did it, whether or not there was an agreement prior to that for him to do that sufficient for the charge of conspiracy, which they have not done so in this particular case, Your Honor.
All right, thank you. I found there to be a factual basis for this plea, and I will accept the plea as freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences.
He sounds over it.
And let me say a couple of things. Only one overt act, as we all know, needs to be proven to establish RICO. On counts 27 and 29, I believe that the defendant's own words inculpate him in the crimes, and I note that he talked about telling the victim to take off the earrings too, which was a part of what was stolen in the case. That certainly seems to, in the court's estimation, inculpate him in those crimes as an absolute willing participant. 31, understandably, considering what we see on video, the defense has really not argued anything at all. Appreciate that, that y'all acknowledge that at least that is pretty clear. In counts 32 through 39, the video, in addition to State's Exhibit number 1, shows the officer to be in uniform, and I do not think that charging attempted murder is an overcharge, considering that Mr. Eppinger, and we hear 6 shots on the video, pumped 6 shots at close range into a uniformed officer, and then laughs about it afterwards, including saying something to the effect of, yeah, he's telling me to get down, I ain't getting down. I think that considering the prior history, the number of different incidents, honestly, almost back to back to back to back, from him getting out on first offender probation and deciding he's not going to change his life, he's not going to take the opportunity he's been given. And many of these incidents wouldn't have occurred, or wouldn't have occurred with the seriousness that they did if he had abided by his first offender probationary condition of not having a firearm in his possession. He couldn't have shot an officer because he wouldn't have had a gun to shoot an officer if he had abided by his conditions of probation. So the number of the separate incidents, the apparent lack of remorse for any of this, the seriousness of the crimes, and the strength of the state's evidence on these particular charges, and the demonstrated determination to continue a criminal lifestyle all go into the court's sentence determination in this case. So the sentence on count 1 is 20 years to serve 10. On count 27, it is 20 years to serve 10 concurrent. 29 is 10 years concurrent. 31, 5 years concurrent with count 1. The sentence on count 32 is 30 years to serve consecutive to count 1. 33, 20 years to serve concurrent with count 32. 34 is 10 years to serve concurrent with count 32. I'm going to come back to 36 because that is required by statute to be run consecutively to anything else that's being sentenced. That's the only one that's that way, right, Ms. Hilton?
Yes, sir.
All right, count 39, the sentence is 20 years to serve 15, concurrent with count 32. 47, the sentence is 10 years, consecutive to count 32, but probated. 48, 10 years, concurrent with count 47, probated. And then 36 is going to be 5 years consecutive to count 47 and probated. I believe that is, honestly, I'm going to have to do a little bit of math right here.
All right, so the math on that.
75 years to serve. To serve 40, followed by 15. No, I don't know what the math comes out to be.
So you
But
said 20 to serve 10 on count 1.
20 to serve 10.
20 to serve 10.
Concurrent.
1 concurrent.
10 to serve concurrent. 5 to serve concurrent with count 1. So that's a total of 20 served 10 right there. 10 probated.
Okay.
All right. Count 32 is 30 years to serve consecutive to count 1. So that's another 30 to serve. Count 33, 20 to serve concurrent with count 32. 34, 10 concurrent with count 32. So right now we're at 50, serve 30.
So 30.
Yes. If there's 30 to serve,
40.
To serve 40,
No.
because it's 20 to serve 10.
clearly this is why lawyers end up lawyers and not scientists or mathematicians, although that's their job.
Attempted murder, it was 30 to serve.
Yes, consecutive to count 1, which is 10 to serve. So that's 50 serve 40 at this point. Count 39 is 20, serve 15, concurrent with 32. So that's not any additional time to serve. So, and then
Notice how Whitaker is framing this sentence within what he's already serving. I feel like that's very strategic on her part. She wants to sentence him to something serious, but in her sentencing, she spelled out, she's like, I found he inculpated himself on that theft by taking. He talked about the earrings. That's willful, that's intent. The officer thing, I find that the officer was identified. He shot at him 6 times. And, I'd argue, if you shoot 6 rounds, if we apply that to every time there's an officer involved shooting, even if it's the officer doing the shooting, in the heat of a moment, I think a lot of people don't realize how many rounds they're firing. So 6 rounds to me doesn't mean somebody was just blasting for like 10 minutes, right? But she didn't go into anything about affiliation to YSL. She really didn't harp on a finding. Count 1. Yeah, you got him. He definitely did all of this at the insistence of YSL, Jeffrey Williams. So I think she's finding a way to sentence him harshly without giving him extra punishment.
47 is 10, probated consecutive to 32. 48 is 10, probated concurrent with 47. And 36 is 5, consecutive to 37, probated. So that's...
Consecutive to 47?
Yes. It's at least 65 to 40.
And would that run concurrent with his current sentence?
How long is he going to actually serve on that sentence?
I understand it would take 40 days.
45 years.
45.
And around currently with his sentence he is currently serving. All right, that is the ruling of the court. And we are adjourned. He may be taken into custody.
Judge, is this Alfred to all of these counts?
Yes.
I didn't know if there was some that weren't that.
It's every one of them.
All right, there we go. And it looks like it ends there. I mentioned something in the chat, so... Well, actually, let's start with, shout out to AJC. They've done great coverage through and through of this whole YSL trial. Every time there's an update, they include key context. They do a really great job. Joseph Papp, Shadi Abu Saad, they've been in and out of the courtroom throughout this trial. There was another guy in the beginning, Bill, I think it was Bill something. But really, since trial kicked off, it's been Joseph and Shadi. But Joseph said, I just wanted to thank all my new followers and readers we've gathered since Shadi and I started to cover this case in May of 2022. Thank you for reading and supporting AJC. We're going to take a look at something in this article that I thought is a little surprising. He says, it's been 1,128 days since Young Thug and 27 co-defendants were indicted by Fulton County's DA office. Monday was the end of the sprawling case after Christian Eppinger, the last remaining defendant, took a plea. Now, to highlight the math, you guys, 75 years to serve 40, but that runs concurrent with 45 years he's already serving, which is why I just paused to say, seems like Whitaker, couched a harsh sentence into something that practically wouldn't add anything to his time in custody. So, there's that. Here's what I wanted to show you. Heading into the trial, Shawana Edmond, this is Donovan Thomas's mom, said she was optimistic the people responsible for her son's death in a 2015 drive-by shooting would finally be held accountable. Before bringing the charges, Willis promised Edmond prosecutors would try to get justice in the 2015 killing of Donovan Thomas outside an Atlanta barbershop. Now, remember throughout the trial, with some of the other plea deals that happened in YSL Trial 1, and then also for sentencing with the acquittal, where we really only had a sentencing for the single gun charge for Shannon Stillwell. The prosecution wanted to make sure victims were in the gallery for things like this. So even they wanted to hold off proceedings because the family members weren't there. But then look at this. Look at this. Keep that context in mind. The death of Thomas, who authorities said was a ranking member of the rival Englewood family gang, if gang, allegedly sparked a years-long feud between the two groups and retaliatory shootings across the city. Willis said this targeted killing created violence like Atlanta has never seen. One of the vehicles used in the deadly shooting had been rented by Young Thug, prosecutors said. But Edmond was stunned last week when, unbeknownst to her, no one contacted her, the final defendant, Demise McMullen, charged with her son's murder, was allowed to plead guilty to a reduced count of aggravated assault. So here's a quote from her. I voiced my opinion. I told them, you guys have really put a dagger in my heart. You let me down, said Edmond, who sat through a year of grueling testimony. I did not know that last defendant was going to walk away with aggravated assault. So, all of this, we consult, we want to stop proceedings to make sure the family members of the victim are able to be in court for pleas, for sentencing, for the acquittal, apparently. But when we do this plea to reduce the last person that could have been convicted for your son's murder, when we're about to reduce that to ag assault in a negotiated plea, that's not something we left up to Whitaker to figure out. Now we don't find it necessary to go and inform you and make sure your victim advocate's able to speak with us. I think that's really interesting. I think that's pretty disappointing. I don't like the idea that the presence of victims' family members could be so palpable in a gallery during trial that it could prejudice the jury. Because imagine those on trial are actually innocent and you get a victim's family member in the court crying. And jury feels bad for mom crying in the gallery and they feel like they need to find justice and that they have to convict. Sometimes those emotions are powerful, even if the person on trial isn't the person that actually did the thing. Right? So I'm not saying that the family member having a say here would have changed the outcome of what's going on here. But it's weird that the state at every step seems so insistent on having the family members present in the gallery during YSL Trial 1. But when they're doing this plea deal, they just say, just pretend they don't exist. Like, just forget about it now. Let's act differently now. It's just not consistent. So, Dean Nicole, does he qualify for parole? I think some questions of eligibility there would come down to his behavior while in custody over the next couple of decades, before they can even start considering that. I didn't hear her mention, any eligibility, and it's not mentioned here in this article. And I don't know the specifics of the sentence for the 45 years he's already serving. So there could be parole eligibility over there, or there may not be. So I'm not really sure on that. But even if there were, right, let's say he is parole eligible, he's got to keep a clean slate for quite a while to make that a reality, if it's even on the table. So I don't know the specifics, but if he acts up, it'd be off the table anyway. Yeah, and Cherry, that's how I feel. I feel like he got, it's a harsh sentence in and of itself, but it doesn't add to the time that he's looking at anyway. It's couched within a 45 years that he was already sentenced to for another case. He's 25 right now, AK. Oh, he's only 22? I thought the article here said 25. He was 22, I think, when the officer shooting happened. So that would make him 25 now. Yep, 25 according to AJC right now. Let's see. And then Sun Goddess says, I watched the trial highlights of a white guy who on video was seen reloading and then shooting his black wife to death. Yeah, so Taylor Umbridge was just covering that. That was a quick trial. That was a quick trial. So I only really got to watch 1 day or so of it. Oh wait, this is a different case because this is saying wife. This is saying wife. So there's another case that happened last week. It was a first date. And I believe he was found guilty of all charges that he was facing. He gets home, he just kills this woman after they had a first date together. So I think we're talking about 2 different cases, but just crazy both scenarios, right? But he was sentenced to less than 25 years. The justice system is racist. Maybe that was, and maybe... What was that guy's name? Let's see. Let's see. I know Kathy had posted the updates. Yeah, Sade Robinson was the victim. And I know it's like any loss of life is sad, but that's a young victim. And, you know, not to play the balancing game, but when someone loses their life at a young age, it's like more is lost. And it just always seems like an extra layer of tragedy. Let's see. Maxwell Anderson. Okay. Maxwell Anderson. My brain wanted to say Zachariah Anderson, and I know that that's a totally separate trial. And the Anderson is what was coming in. But yeah, guilty on all charges there. And then, so I'm not aware, Sun Goddess, if this is a separate case, I'm not aware of the specifics, like the name, but it is making me think of this case here, where we had a senseless killing after a first date. It didn't seem like the jury had to deliberate too long. It seemed like pretty cut and dry. So, and was he, when is sentencing for Maxwell Anderson? Or did that happen already? Verdict, reaction, and sentencing. Let's see. Oh, sentencing is going to be August 15th for that. So it's a little bit of a ways away, but I feel like tomorrow we'll wake up and it'll be August. So yeah, thanks, Miss Ann. So August or September of this year. So sentencing is coming in August. Just crazy, 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 crazy. It's scary, you know. It's you hear how people turn on their location when they're going on dates, but this is a good example of why. And it seems like that's a crappy way to live, to have to take the safety precautions, but, and honestly, putting on your location might not save your life, right? I mean, especially if the person who's planning to do something heinous against you doesn't care or doesn't know, like, how would that deter them? But same thing, you know, I think last week or a few weeks ago, the FBI also released some of the files in relation to Shanquella Robinson. Not too much new in those files. A lot of the stuff is redacted. There is civil litigation going on. Shanquella Robinson was the girl who went on a vacation to Mexico with a group of friends. And when the vacation was over, her friends come home with her luggage and tell her family that she died of alcohol poisoning. But then a video, like, I don't know if it was a TikTok or an Instagram Reels, like a story, but there was some vertical video where the friends and her and Shanquella Robinson are in a hotel room, and another female that's on the trip is hitting Shanquella Robinson. So questions were raised, and as of right now, it looks like the only litigation that's ongoing, the only action that's ongoing is a civil case, where I think the mother, Shanquella Robinson's mother, is suing one of the girls, probably the girl that's in the video doing the swinging, and that girl has changed her legal name. So, but just all of these things, like waiting for sentencing, waiting to see if justice comes about. But when I saw that news, I was like, wow, that was a long time ago that happened. And they're just releasing the information now. But there we go, guys. That is the end of the YSL saga. I just did air quotes because we have an appeal on the way for Antonio Sledge in relation to his probation revocation, but there's other issues that are separate from the probation revocation. So it's not just related to the probation revocation, although that's a centerpiece of it. There might also be something coming up with others in relation to some sentence or probation revocation from the YSL trial. So you guys know the drill. Make sure you're following Happily Angry Lawyer and the Fit Lawyer ATL. As soon as that appeal drops, we'll get together. We'll do another live. So the trial level chapter of YSL is closed. But we still have some matters to deal with relating to these sentences and the plea deals and the convictions associated with them. So it's like done without being fully done. So we'll keep up with that. Again, I can't redirect the stream over to Classy, who is covering the Karen Reed trial. I have this instead set to go to Justice Served, and I wanted to wear my hat, but I didn't want to wear a Justice Served hat to watch like a plea and a sentence, because I didn't want it to be a message. Justice Served is their brand, but I didn't want it to look like a message about whatever was going to play out here. But Justice Served TV is also covering the YSL trial, and I can redirect to them. So this will take you to them automatically. And then I'm dropping the link to Classy in the chat since I can't redirect to him. So you've got to choose your own adventure, chat. Where do you want to go hang out? And I heard there's been a motion for mistrial, like a bunch of craziness there. So big thank you here to Classy for showing some love. Go show him love back. Thank you again for the 5 gifted subs. Mike the Mob, thank you so much for your super set. Hey, Cat in chat, good day, good day. It's been great to see you guys again. And Leo Senpei with the spoiler here about the Karen Reed trial. I won't read it on screen, but there we go. Oh yeah, and Factual Lie. The Gregory King, also known as Deaf Greg. Taylor Umbridge did coverage of the indictment against Greg. He's going to be a lone wolf, put on trial in Fulton County, being some leader of some gang. And he's a relative of Jeffrey Williams. So there's going to be some hot mess going on with that too. I mean, I can say that, I feel like, with certainty. That's going to be some hot mess. But that's another one to look for. And I think enough people have been looking for coverage of it that maybe we'll see like Fox 5 Atlanta or maybe AJC come into the fold there and do some coverage live from the courtroom. Or if that starts after the Diddy trial's over, maybe Sylvia will be back in Fulton County because I think she's been in New York. So hopefully someone's in there. But yeah, another crazy one, Factual Lie. Like, nothing surprises us anymore. Love you right back, Peter Ortiz. And by the way, you asked earlier, new hat. I got this in time for your birthday, but it might not have been showing on screen. It's just the docket like it's hot. Although I think if we went with drop it like it's hot, it'd be pretty relevant with all these null process, right? They're just dropping these charges left and right. But we've got docket for the wordplay there. And then let's see. Shout out to Jazzy, Chad Diggy, and FFS figuring it out in the chat. Other than that, you guys, I updated the description with what Eppinger was facing, what his charges were. I haven't updated his final disposition, but again, if you go back in the video and see where Hilton showed it on screen, that will break it down for you. I did also link to when we talked about the motion to suppress identification. I went on a rant on that little stream clip. You know, shuffling the photos, trying to lead the witness to point to the person that you want them to identify. All of these problems with witness identification and police lineups. There was I thought, a pretty good motion to suppress filed by Eric Johnson on behalf of Eppinger. That's now linked in the description. Until next time, you guys, whether that's for the appeal for Mungtunk, or maybe if we get some stream coverage or motions related to Greg King, we'll meet again. And until then, see you somewhere in a Karen Reed chat. Bye, you guys.